the reasonable person. I'm Sandy Sandbar. This presentation is an overview of the legal concepts and characteristics of the reasonable person, including doctors, judges, and jurors in cases of personal injury, medical negligence, informed consent, and informed refusal of treatment. What does it mean to be reasonable? The reasonable person is the legal standard for lawful behavior. It is a concept that is created by appellate courts whose decisions are memorialized as judge-made law or common law or case law. It is a fictional or hypothetical person who approaches any situation with the appropriate amount of caution and then takes action sensibly. If the person's behavior is as good or better than a fictional, reasonable person in the same situation, his or her actions are not negligent. Conversely, if the person's conduct falls short of what a fictional, reasonable person would do under the same circumstances, then his or her actions are negligent. At common law, if the negligence results in an injury, when a person acts negligently, then he or she is subject to liability. So which court created the concept of the reasonable person? Historically, we have to go back to 1837, an English court of common pleas established in the case of Bond versus Menlove that at common law, the reasonable person standard is objective as opposed to subjective. In the case of Menlove, a farmer piled a haystack near his neighbor's cabin. Subsequently, the haystack caught fire and burned his neighbor's cabin down. Well, the neighbor sued. The farmer argued that he should not be liable because he genuinely did not consider the haystack may cause his neighbor's cabin to burn down. That was subjective. But the jury found that the farmer's actions were objectively unreasonable. And then the court held the farmer to the standard of a reasonable person and found him liable. Interestingly, George Bernard Shaw noted that the reasonable person adapts to the world. The unreasonable person persists in trying to adapt to the world, or rather adapt the world to himself or herself. But what he also said is that all progress, therefore, depends on the unreasonable person. The conduct of a reasonable person weighs heavily upon an injury case. To hold a person accountable for an injury caused by negligence, it must be determined whether or not the defendant acted as a reasonable person would have in a similar situation. Failure to behave with the degree of care that a reasonable, prudent person would exercise represents negligence. The conduct would be unreasonable. The opposite of unreasonable is reasonable, rational, sensible, logical, just, wise, good, intelligent, fair, and justifiable. Well, let's look at situations where the law considers a person's conduct as unreasonable. And there are three situations to consider. The first is negligence per se. This means negligence by or in itself. Here, an actor or a doctor is negligent if, without excuse, the doctor violates a statute that is designed to protect against the type of accident the actor's conduct causes. And if the accident victim is within the class of persons the statute is designed to protect, then there lies liability. So in negligence cases, a defendant who violates a statute or regulation without an excuse is automatically considered to have breached his or her duty of care and is therefore negligent by law. The fictitious, reasonable person would not violate a statute. For example, in the context of a motor vehicular accident, if one of the drivers is driving under the influence of drugs or alcohol, he or she will be found to be negligent per se, as a matter of law. In medicine, another example, there are certain disorders that must be reported by the provider to the public health department. Failure to do so is negligence per se because it violates a statute or regulation. Well, the second type of negligence at law, whereas it is considered unreasonable, is negligence as a matter of law. This is different from negligence per se. In negligence cases where there is an undisputed fact or facts that is clearly unreasonable and so conclusive of negligence in conduct or omission in violation of a standard of care, the judge may declare that negligence is established as a matter of law. The judge makes the decision. The judge decides the case because there is no question to be submitted to the jury. For example, in 1947, the Supreme Court of Washington ruled in the case of Helling versus Carey that the defendant ophthalmologists were negligent as a matter of law for failing to administer a diagnostic test for glaucoma to the plaintiff. Expert medical testimony was uncontroverted that the custom was not to administer the test to persons under the age of 40. That's the age group of the plaintiff. And that's because of the rarity of glaucoma when it would appear. Nevertheless, the judge characterized the facts of Helling as unique and stated that liability was imposed under the facts of the case. There is a third situation of unreasonable conduct, and that's called the thing speaks for itself, or in Latin, it is called res ipsa loquitur. Here, the thing speaks for itself and does not require expert medical testimony to explain the facts. This is a doctrine or a rule of evidence in tort law that permits an inference or presumption that a defendant was negligent in an accident injuring the plaintiff on the basis of circumstantial evidence if the evidence was of a kind that does not ordinarily occur in the absence of negligence. In 1863, in the case of Byrne versus Bodle, that was the leading English case, and we got the common law from the English common law. Here, this leading case formulated the negligence doctrine of res ipsa loquitur. What happened is that the plaintiff was walking along the public street when he was struck by a barrel of flour falling from a window above and evidently lost consciousness. So he brought suit in negligence. The plaintiff could not prove negligence. He was unconscious. He did not see what happened. The defendant had a shop adjacent to the road on which the plaintiff was walking, and the barrel appeared to have fallen or was dropped from the shop. Because the plaintiff could not testify, two eyewitnesses testified that they saw a barrel falling, but there was no evidence of negligence. So the trial court said, the case dismissed. You have no lawsuit. So the plaintiff appealed to the appellate court, and the appellate court thought that a barrel could not roll out of a warehouse without some negligence. And to say that the plaintiff, who is injured by it, must call witnesses from the warehouse to prove negligence was preposterous. So the facts of the case were so obvious that further proof was unnecessary. The thing spoke for itself. Well, in the United States, the classic res ipsa loquitur case in medical malpractice was published in 1994 in the case of Ybarra versus Spaniard. Here, the plaintiff had appendicitis and underwent surgery. After induction of anesthesia and in the course of preparation for surgery, members of the surgical team adjusted the plaintiff on the surgery table so that his back rested against two hard objects. Post-operatively, the plaintiff had neck and back pain, which he never had prior to surgery. His symptoms worsened, and he eventually had paralysis. Well, the evidence established that his condition was the result of trauma. He brought suit as a personal injury case, and the Superior Court of Los Angeles County in California said, you've got no lawsuit. It entered a judgment of a non-suit as to all the defendants. So the plaintiff appealed. The Supreme Court of California reversed the lower court's ruling because the res ipsa loquitur doctrine applied to the defendants because they had control over the plaintiff's body and they had control over the instrumentalities that might have caused the injury which the plaintiff sustained. Well, in order to prove res ipsa loquitur, the plaintiff must do three things. First, the plaintiff must show that the incident was of a type that does not or generally happen without negligence, that it was caused by an instrumentality that was solely in the control or under the control of the defendant, and third, the plaintiff did not contribute to the cause of the injury. In the case of the operated person, the plaintiff was anesthetized. So a plaintiff then, who establishes the elements of res ipsa loquitur, can withstand a motion of summary judgment, in other words, not to be dismissed without trial. And then the jury will have to decide whether or not there was negligence based on the facts of the case. Well, take a surgeon that performs an open laparotomy on a hospitalized patient. At the conclusion of surgery, the nurse informs the surgeon that the instrument and sponge count are correct. The abdomen is closed. The patient recovers and is discharged home. But a couple of weeks later, that person returns with abdominal pain, and the surgeon discovers a clamp in the abdomen. So the patient is reoperated. In this case, the jury looks at the behavior of every member of the surgical team based on what a reasonable person would do. A reasonable person conducts an accurate sponge and instrument count correctly. A reasonable person does not leave a sponge or a clamp in the patient's abdomen. The jury decides the case by looking at each person's actions compared to what the fictional reasonable person would have done if confronted with the same circumstances. Because a reasonable person would not leave a clamp in the patient's abdomen, then the provider or providers that left the clamp in the abdomen would be negligent. The jury decides the case in favor of the injured plaintiff patient based on the finding of negligence against the providers that left the clamp behind, including the surgeon, the person that made the sponge count or instrument count, and the hospital that employed the surgical assistant. Now let's look at the reasonable person standard in negligence. The reasonable person standard has been created to provide the judge, the courts, and the juries with an objective test that can be used in deciding whether a person's actions constitute negligence. The reasonable person standard is the amount of care and caution that an ordinary person would use in a given situation. So the standard then depends on the situation. It is a fictitious legal standard that applies to evaluate the behavior of each person involved in an accident or injury. So the jury, the trier of fact, sometimes it's the judge alone, looks at what each person did to determine if the actions were at least as careful as a reasonable person. In civil lawsuits, the burden of proof in such cases is the preponderance of the evidence, which means more likely or more probable than not. That is just about 50%. It's a low burden. If it is proven that the defendant acted negligently and that the negligence itself resulted in an accident or injury, compensation is due to the victims for their damages, and that includes medical expenses, pain and suffering, economic and non-economic damages. Now, there are exceptions to the general reasonable person standard. The general reasonable person standard does not apply to blind people. In the case of Fletcher versus Aberdeen, the Supreme Court of Washington held that a blind person should be held to the objective reasonable standard of a blind person, not a sighted person. And children are not expected to act similarly to how an adult would. Courts hold children to a modified standard. Their conduct is compared to that of other children who are the same age and alike in their amount of experience and knowledge. For example, a landlord tried to file a lawsuit against a tenant for property damages to a dwelling that he had rented. Well, the landlord sued a 2-year-old child who started the fire by playing with a cigarette lighter. Well, a child is just not held to the same standard as a reasonable adult. In the case of Robert versus Ring, the Minnesota Supreme Court held a 7-year-old boy to the standard of an objective 7-year-old boy, not to that of an adult. So let's look at then the reasonable person test. How do you test that it is objective? The reasonable person test, again, is not subjective. Its purpose is to give the jury a concrete, uniform standard when they are looking at the actions of each party in a case. The test applies to everyone in society. The issues that must be considered are how likely a certain act is to cause harm, how serious the harm would be, and what is the burden involved in avoiding the harm. In 1931, a New York case, the T.J. Hooper case, involved 2 barges that were transporting cargo. The weather got bad and the cargo sank at sea. The cargo owner sued for the value of the lost cargo. Well, the plaintiff contended that the tugboat owners were required to use reasonable care and skill in the service they undertake. They are bound to respect barometer readings and weather indications. Because they failed to do that, they were liable for resulting damage, that is, the loss of the cargo. The plaintiff also contended that the tug owners were negligent in not anticipating the storm or taking refuge at Delaware breakwater. And the plaintiff stated that the tugboats were unseaworthy because the owners did not have effective radio sets capable of receiving the forecasts of unfavorable weather that would be broadcast along the coast. Now, the defendant argued that the reasonableness of the decision not to install a reliable radio safety device should be determined by common practice, what others were doing, what other owners of tugboats were doing. Was the question then for the judge and jury, was the defendant tugboat owner negligent when it failed to equip its tugboats with radio sets to pick up weather reports? The judge held that courts must in the end say what is required. There are precautions so imperative that even their universal disregard will not excuse their omission. The judge also stated that in most cases, reasonable prudence is in fact common prudence, but strictly it is never its measure. A whole calling may have unduly lagged in the adoption of new and available devices. The court held that the owners of the 2 tugs were negligent in not anticipating the storm that sank the barges. The court also concluded that the tugs were not seaworthy in failing to have effective radio sets capable of receiving weather reports. So the tug owners had a duty to supply effective receiving radio sets, since such radios were part of the reasonable care and skill in the service that the tugs provided. So a successful negligence-based claim hinges on the plaintiff's ability to prove a defendant did not act reasonably. The plaintiff must show that the risk of harm was foreseeable and that the defendant was aware that his or her actions were wrong and unreasonable. And the plaintiff must establish the alternative action which a reasonable person would have taken. So the jury will objectively consider the individual's conduct based on the person's knowledge, awareness, and mental capacity to have similarly the action of a reasonable person. The law will not make unique allowances for beginners, learners, or trainees in a special skill. They are held to the same level of care or conduct that a person who is reasonably skilled would exercise. Now let's focus more on the reasonable doctor. In the case of Davis versus Armakos, the Court of Special Appeals in Maryland ruled that doctors are not held to the reasonable person standard. Because of their specialized knowledge, education, training, and skills, doctors must be held to the standard of a reasonably competent healthcare provider engaged in similar practice and acting in similar circumstances. In that case, Dr. Davis is a neurosurgeon who performed an anterior surgical disectomy and fusion of the of his spine, and that was complicated by a pinpoint opening at the end of the incision. The patient, Armakos, eventually developed MRSA abscess. The patient plaintiff alleged that surgery was neither medically necessary nor appropriate, that there was no proper informed consent, and that the diagnosis of his postoperative infection was delayed. Well, the trial court, that's the trial judge in Baltimore, instructed the jury that it could consider what a layperson would deem reasonable standard of care. The defendant doctor objected and asked that the standard of care be measured by the expectations for a neurosurgeon. The judge refused to modify the jury instructions, and the jury returned a verdict in favor of the plaintiff in the amount of $329,000. Well, on appeal, the appellate court, that's called Special Appeals Court in Maryland, ruled that the jury instructions were improper and therefore ordered a new trial. The appellate court, that's the middle appellate court, stated that medical malpractice claims are not general negligence claims. And so jury instructions on general negligence, although correct statements of Maryland law, are not supported by the facts of the case, which centered on the allegedly negligent conduct of a physician. Accordingly, the court held that the trial court that made the first decision was in error in giving general negligence instructions on a malpractice case. Well, the plaintiff was not satisfied, so he appealed to the higher court. That's the highest court in the state of Maryland. There, what happened is that the higher court reversed the middle court's decision. It held that the trial court's instructions did not mislead the jury as to the applicable law. The court has characterized any medical malpractice tort as a traditional negligence claim. Thus, the principles which ordinarily govern in negligence cases also apply in medical malpractice cases. The standard of care applicable to a physician in a negligence action is derivative or is derived from the general standard of care in negligence actions. The conduct of a doctor with a special training and expertise is measured against the standard of a hypothetical, reasonable person with similar training and experience. The doctor owes a special duty of care to a patient that is beyond the duty that would be owed by a general member of the public. The plaintiff may also be required to meet certain threshold requirements, such as providing a certificate of a qualified expert supporting the plaintiff's claim. And at trial, expert testimony may be necessary to assist a lay jury in understanding the extent of the enhanced duty created by the expertise and whether that duty was breached in a particular circumstances. Well, now let's turn to the jurors. What's a reasonable juror? Well, the jurors that hear a case become the reasonable person. They decide what a reasonable person would do or not do to avoid injuries in a given situation. When deciding a negligence case, jurors may assess the evidence under the following theories. First, prescriptive, second, statistical, and third, hybrid. When they consider the prescriptive method, that means that some right or obligation has become legally established or accepted by long usage or the passage of time. That's prescriptive method. On the other hand, the statistical method of reasonableness may be understood as what is average or common. It looks to the way in which actual people are in the habit of acting. And then the hybrid is merely the combination of both. So if we go a little further with the descriptive method, we're looking at a theory where reasonableness may be understood as to what is good, welfare, maximization, community values, virtue, respect for freedom or rights, or ethnic care and justification. But when we look at statistical method, under the purely statistical notion, reasonableness may be understood as what is average or common. It describes a certain average of conduct that is necessary to the general welfare. It looks to the way in which actual people are in the habit of acting. The hybrid method, here, reasonableness has two different types of components performing essentially the same function like a hybrid car. This method posits that reasonableness is neither purely prescriptive nor purely statistical. Instead, reasonableness is partly prescriptive and partly statistical, as in normality. This hybrid concept may offer the best general theory of reasonableness, which should be understood as a judgment that is informed by both prescriptive and statistical consideration. So the judgments of reasonableness by jurors are best predicted by relevant average and the ideal together, rather than by either the average or ideal alone. Judgments are systematically intermediate between judgment of the relevant average and the ideal. Thank you.